So now with this, we'll move to our last presentation. We have Mr. Abhineet Maurya, who will be locating the philosophical basis of dignity discourse in Indian law. Over to you.
Hello, everyone. I'm Abhineet. I am a recent graduate of NTU Delhi. The paper I'm presenting concerns the philosophical foundations of dignity in Indian constitutional discourse. As Professor Prasoon already mentioned, my paper is sort of a continuation of the discussion that we had during the first session yesterday. But I also hope that it draws from and also rounds the discussion that we've had since. What this paper looks at is various conceptions of dignity in the literature of moral philosophy and come up with a defensible idea of dignity that can be used as an understanding for dignity in law generally, but specifically within Indian constitutionalism. We will start with looking at some objections to the use of the concept of dignity and build our ideas from there. Ruth Macklin, a Yale bioethicist, in an influential 2003 article, criticized the idea of dignity as being vacuous. What Macklin's criticism hinged on was the argument that appeals to dignity are either vague restatements of other more precise notions like autonomy or mere slogans that add nothing to the understanding of the topic. Since then, the criticism about the concept of dignity has multiplied, and I think it is best captured by the provocation that is offered by Michael Rosen. He asks us to consider the words of Article 1 of the UDHR. All human beings are born free and equal in dignity and rights. What would be lost, Rosen asks, if one were just to say all human beings are born free and equal in rights? What is lost exactly? Or are we exactly where we started with freedom and equality? This criticism pulls us in one of two directions. We can abandon the claims based on dignity and search for more real concepts underlying it, like autonomy, and try to interpret them. Or we can search for a philosophically defensible thesis of the contents of dignity that brings something to the table that other concepts do not, thus preventing its collapse into other concepts. So let's sit with that thought for a moment and examine what the Indian Supreme Court jurisprudence tells us about the meaning of the word dignity. For the last half century, the Supreme Court has given a slew of judgments claiming what human dignity entails. But these claims mostly take the form of right X follows from dignity. But very few of these judgments actually discuss what dignity means or even discuss in detail why right X follows from dignity. The lengthiest exposition about the contents of dignity was given by the Supreme Court in the Puttaswamy cases in context of right to privacy and Aadhaar. In the Aadhaar judgment, Justice Sikri, writing for CJI Deepak Mishra himself and Justice A.M. Khanvilkar, stated that dignity is to be treated as empowerment which makes triple demand in name of respect for human dignity, namely respect for one's capacity as an agent to make one's own free choices, respect for choices so made, and respect for one's need to have context and conditions in which one could operate as a source of free and informed choice. Now, this explanation is also very similar to what the Delhi High Court said in the Nas Foundation case, where it said, at the root of dignity is the autonomy of private will and a person's freedom of choice and of action. Now, looking at this, Ruth Macklin's objection seems tempting, because this is basically the idea of autonomy. One is tempted to then go down the first route to sort of claim that, well, dignity is nothing more than autonomy. Therefore, what we should really be focusing on is autonomy and trying to interpret that. But the kind of rights that dignity has been made to anchor do not exactly support dignity's identity with autonomy. As Professor Erin mentioned yesterday, that autonomy assumes that we are all on islands, right? And rights like livelihood, healthcare, education, which have been linked to dignity by the Supreme Court, don't fit within this vision of dignity as autonomy. The bottom line is that the Supreme Court has a conception of dignity that is broader than other concepts like autonomy, but whose precise content is yet to be judicially expounded. That is why we must go into the second direction and we must look at new approaches to dignity. So yeah, we are back to the blackboard. So let's go to moral philosophy. What does a broad review of literature of moral philosophy tell us about the meaning of the word dignity. And a broad review of literature divides these definitions mostly in four camps. One is obviously the theological camp, the most prominent example of which is the concept of imago Dei in Catholicism, whereby human beings are treated as sacred for being made in the image of God. Of course, this cannot be made a moral ground for dignity in modern and secular society, but many argue that our modern concepts of dignity owe an unacknowledged debt to this Christian theological concept, and that is why it remains popular in moral philosophy literature. And the second is obviously the legacy of Kantianism, whereby humans are considered having an innate moral worth, noumenal worth, by virtue of having the capacity to reason. And this emphasizes the need to treat human beings, following the Kantian aphorism, as ends in themselves rather as means to other ends. The problem, of course, is that this concept too collapses into the idea of autonomy. Then we have the idea that is endorsed by scholars like Appiah and Waldron, that dignity is a purely legal construction. They argue that through law, dignity modernized the feudal construction of dignity as elevated rank associated with nobility. As per this account, the treatment and deference that were historically due to nobility are constitutive of what we call dignity. And then the last perspective is dignity as authoritative standing to make second personal claims. This view claims that dignity is a relational concept, which is neither inherent and not merely historical accident with no moral basis, but one that comes into existence with actual second person encounters, meaning encounters with other people. For obvious reasons, we cannot take the theological paradigm and we cannot take Kantian paradigm either if we want dignity to be something more than autonomy. So the two contenders to give meaning to the content of dignity are the members of the third and the fourth camp. Let us take into consideration the third view. Waldron argues that dignity is not an innate moral right, but rather a purely legal construction. Its genealogy lies in the way dignity was in earlier societies, a master of rank, a marker of rank used to justify special protection and ceremonial respect for kings, aristocrats, officials, etc. The modern idea of dignity, according to Waldron, is a democratized version of this rank idea, now attributed to every human being. So as per Waldron, dignity is not a mere source of right, but a right in itself, a right to be treated as someone of high status in society with implications for how laws and officials behave. So what gives the idea of dignity its structure and meaning is its historical and legal roots. However, in my view, there are a bunch of issues with this view, and I'll highlight three of them which are relevant to us. The problem with the historically grounded construction of dignity is that it makes claims to dignity unintelligible in contexts which do not share that historical meaning. Dignity in Indian constitution is not a reference to a standard of treatment of medieval European nobility, but rather an intelligible moral concept. Descriptive history of a concept cannot be used as normative justification. In Waldron's case, what acts as a justifying norm is actually equality. And Waldron claims that dignity is closely related to equality, obviously, but it runs us into the same problem of collapsing of categories. Only instead of autonomy, we now have equality. If equality of treatment is the normative foundation of dignity, then normatively speaking, any treatment that can be equally guaranteed can make the concept of dignity. The fact that it is similar to the treatment of nobility is a mere chance of legal history. That does not explain the direction that the Indian Supreme Court has taken, where specific treatment is taken as, whereas particular treatment is taken as foundational to dignity. This leaves us with the fourth view, which I believe gives the most sensible account of dignity for our purposes, the view that is taken by Rainer Faust. According to Faust, to see human beings as having dignity is to see them as persons endowed with a right to justification of all actions or norms that affect them in morally relevant ways, and acknowledging that every moral person has duty to provide such justification. Therefore, dignity rests on the moral status of the person as a reason-giving, reason-demanding, and reason-deserving being. The concept of dignity is related to what Professor Vijay Raghavan talked about yesterday in relation to under-trials. That what registers as a violation of dignity to people is not even being heard by judges who are overseeing their case. Miss Isaac talked about it just now as well, being heard in procedural proceedings. Not only does this idea of dignity encapsulate the idea of autonomy, it also demarcates the extent to which what we think of as socio-economic rights can be covered by the notion of dignity. Faust writes that what violates people's dignity is not something like poverty itself, but that they're compelled to live in poverty due to human actions and structures. The violation of dignity consists in being ignored, not counting, being invisible for the purposes of legitimizing social relations. And Kshetra also talked about it, about this invisibilization just now in context of tribal forest rights. Now, why do I think that this is a good picture? First reason is that this is a moral picture rather than a historical one. It can be interpreted independently, unlike Waldron's account, which restricts us to a legal historical paradigm of interpretation. Additionally, it is a moral concept of dignity that cannot be reduced to other ideas like autonomy or equality and has its own life. Now, Faust's view of dignity is a broad one, which makes dignity the foundation of democratic politics, which legitimizes social relations, and it has not just legal but also ethical, social, and political dimensions, which can very well be what can be understood as the meaning of the word dignity in the preamble of our constitution. Because the constitution is not merely a legal document, but also encompasses moral and political values. But what dignity can mean for us as far as part 3 of the constitution is concerned has to be a narrower understanding of the political value of dignity, given the specific role that courts and legal institutions play in society. Dworkin talked about the distinction between principle and policy, and the idea is that the constitutional legal principle of dignity cannot mean the priorities of a welfare state. Professor Preetham yesterday discussed the idea of dignity inflation, which is also very closely related to this problem. Here too, Faust can be of help, especially the understanding of the difference between injustice and profound injustice as far as violation of dignity is concerned. He says, those relations are unjust that are not sufficiently justifiable in reciprocal and general terms, and those relations are profoundly unjust that systematically thwart the practice of justification itself. The idea of systematic thwarting imputes an agency upon an actor, this case the state. Therefore, a mere policy failure to ameliorate the condition which invisibilizes that person from process of legitimizing social relations, while it is a violation of dignity, would not be judicially enforceable given the specialized role of judiciary in the legal system. However, a practice or a set of practices that actively contribute to this process of invisibilization would constitute a judicially enforceable violation of the right to dignity. And this is what I think Article 21's conception of the right to dignity should entail. And this is the idea of dignity that we are legal institutions in India, but I think in many other jurisdictions can sort of adopt to have like a coherent, philosophically grounded understanding of dignity. Thank you.
Thank you, Abhineet, for that very powerful presentation and for bringing another dimension or content which says that reason giving exercise or giving justification is what counts as citing dignity. And any questions, observations, or comments on Abhineet's paper? Okay. Yeah.
So just no questions as such, but as the floor is open to comments,
No, then we'll wait for people who have questions before making general observations.
I think while people are formulating their questions, I think Saksham can just go ahead. Yeah.
uh, um, uh, thank you for this because and like how the way you collected everything back. I think a general theme with the entire conference has been, and it's a general tendency for lawyers to try to box things up, to to have to pigeonhole stuff and like get some groundings. And the first panel did as that as well. And I think at least if you quench that thirst to some extent for the lawyer inside me, and so thank you for that.
So faith affirming comment that you made. So I'll take that opportunity to ask you a question that towards the end you spoke about what counts as justification. Um, would you want to flesh it further as to uh, what is it that in the public realm would count as reason and justification giving exercise, and what is its link to the public realm and understanding of justice? Because there can be public reasoning, non-public reasoning, religious reasoning, uh, identity-based reasoning. What is the kind of reasoning and justification are we talking about? And how different is it from Habermasian conception of public reasoning?
I think, as far as Habermas is concerned, Habermas's idea is a very, as you mentioned, public reasoning focus. But I think Faust's idea is broader than that, because the way that he conceptualizes the idea of dignity, it is not just a public exercise; it's also a private exercise. He talks about in terms of reciprocal obligation. So, if we are interacting in a one-on-one setting, because the idea is second person came. So, if we are interacting in a one-on-one setting, me treating you as a reason deserving subject and you treating me as a reason deserving subject is what sort of constitutes this like sort of reciprocal obligation. I think Gopal Guru also talks about how we are so obsessed with the idea of freedom of speech, but what we should focus on is this reciprocal ethic of communication. And I think Faust's idea sort of very well encapsulates that idea. That, of course, when we sort of, when we're talking about law, we are obviously getting the state involved. And then when the state is involved, then, obviously we have to scale up, and then we have to go at the level of public reasoning and how, how do we conceptualize public reasoning in this way? What sort of justification sort of, count? And I think when we talk about public reasoning specifically, the reasons that should be given should be reasons that relate to the individual. They cannot be community justifications, right? You deserve this happening to you because, well, it is good for the community. That is not the sort of vision that Faust has, and I agree with Faust that what matters at the end of the day, dignity's relentless focus, as Professor Erin also said yesterday, is on bringing the issues back to the individual. And I think that this view does that beautifully, grounding, dignity so broadly that, as the private reason, public reason, everything that gets incorporated. But at the same time, the issue that the focus on the individual is always consistent.
Thank you. Thank you. Yes. Yes, Professor.
Thank you. I think this is really interesting. And you mentioned a bunch of different kinds of reasoning, but I was actually thinking about bad reasons. And oh, sorry. Thank you. So I was wondering, and you sort of started to answer it in your last answer, but it seems to me that there has to be a qualification of what kinds of reasons are acceptable. And to have that qualification, you have to sort of assume dignity in order to get your answer for the justification for whatever you're asking for, right? So I'm thinking about U.S. Supreme Court decisions from, let's say, the previous century that upheld segregation, and non-U.S. Supreme Court, like lower court decisions. So those opinions have lots of reasons in them. We, I think, who care about dignity, would consider those reasons to be not acceptable, but they are reasons. And I'm trying to work this out, but it seems to me that the only reason that they're not acceptable is not just that they're group-based as opposed to individual, but that they deny dignity. And so I'm just wondering if that gets circular, or how you have an account of justification that that tests the dignity rather than assumes it.
Yeah, I mean, in the past few weeks that I had the time to think about Faust's idea, I think that is the most powerful, like, sort of, objection to the idea that I've also come across, that does Force idea reduce it to a merely formal sort of qualification, and whether there is like a more substantive sort of criteria to the idea of dignity as well. And I think what struck me most when Judge Asad was talking about how accused persons are made to stand with their hands folded, heads down. That is instinctively feel that is a violation of dignity, because that sort of idea of dignity comes from a respect for a human person, which I think, that is, I think, one weakness within like Faust's sort of vision of dignity, in that this idea of respect that people have, and we can sort of think about a lot of other things, like the idea, and something that Supreme Court also has talked about a lot, about the idea of death with dignity as far as euthanasia is concerned. Can a model of reason sufficiently account for that idea of dignity, or do we need like incorporate a broader idea of respect that goes along with this idea of justification as being like the end goal of dignity? And I think that is certainly something that I will have to address if I ever make this thing into a full paper. And I think it is something that I do not have a complete answer to as of now. Thank you very much for bringing that up. And it is something definitely that we need to think about when we sort of try to conceptualize dignity as a whole concept, and not something that just stands in for something else. Maybe we can think of it that maybe the right to justification entails within it a kind of morally complete justification, a morally correct justification. But then again, then we are not treating the idea of dignity as a standalone idea. And maybe that is fine, maybe that is not. But that is, I think, something that requires greater amount of thought to go into it. Yeah. Thank you.
Generally, when I hear these things, I'm tempted to think that any reasoning will not help. Therefore, one needs to have some kind of ethical reasoning. Is what I try to then. Still, when I go back to the way that colonialism was justified, the way that slavery was justified, the way that caste system was justified, everybody was giving some reasoning or the other. Right. Then the question is, the kind of set of reasonings that you develop, even in the name of ethics, are conditioned by already existing structures of social relationships. Right. See, we are assuming that the two people who are trying to communicate with one another are equal to one another. Therefore, the other person owes an ethical justification to the way that he treats the other person. But that is not the case. See, the guy who's standing as a accused, he knows that he can't ask anything. The presumption on the part of the people who are sitting on the pedestal also knows the reason that why they don't want to give the reason. So the point is, somewhere we need to historicize, what kind of social structures of relations can produce what kind of reason. And one way is saying that, she said bad reasoning. I can say that, one should give a ethical reasoning, but this even in the name of ethical reasoning, justification was given to slavery and also colonialism. So those times, those counter arguments that we are giving are not available, because now we are living in a different kinds of era where there is a larger democratic discourse, which was not available during that time. So my point is, one haunting sentence that I read somewhere is, reasoning is not able to explain the rationality.
Right. I mean, Foss also talks about the relationship between reason and power, and this historically grounded structures, and what sort of role reason has in sort of mediating these sort of powers. And I think reason has this sort of very imminent role to play in how these power structures are challenged, right? And the dignity in that sense, and this very procedural idea of dignity that sort of Faust is proposing is to give space to all sorts of people, right? I mean, the kind of justification that were given to, for instance, justify slavery and caste were exactly the sort of power structure that invisibilized people. With invisibilized individual and talked in very broad terms in terms of justification, right? And I think that like at least false idea is helpful to us in this regard is to say that everyone counts. And by everyone we mean every individual, and we just do not mean like every group or every community. So that is, I think, what is sort of different about false idea. And I don't think that any sort of justification that were given about these institutions would count as justification as far as false idea is concerned, because false consideration is very individualistic, very very focused on human person. And these institutions, which in their justification invisibilize that human person, are incongruous to the idea of dignity that he's trying to highlight. Yeah.
Thank you.
Thank you very much.